Assalamualaikum warahmatullahi wabarakatuh. We are going into our third chapter, which is formation of companies. So in this chapter, once we finish, you should be able to discuss the procedures to incorporate a company. What is the procedure for registering a company? Previously, under the Companies Act 1965, there's a procedure whereby you have to do it manually, but now with the new technology, everything is done online. And the fact that with the coming of the Companies Act 2016, SSM or Suruhanjaya Syarikat Malaysia has introduced MyCUID 2016, whereby the registration process is a lot more easier. Companies can operate immediately except for public companies, and the period reservation of name is reduced compared to the provisions under 1965 Act. You have to wait for 3 months. There's a waiting period of 3 months for on the reservation of names, and under the MyCUID 2016, you only need to fill up the necessary information. SSM or Suruhanjaya Syarikat Malaysia, CCM, Companies Commission of Malaysia, has introduced this MyCUID 2016. There are few essential requirements of a company before you can actually incorporate. This has been provided under Section 9 of the Companies Act 2016, whereby a company shall have a name, one or more members having limited or unlimited liability, and then in the case of company limited by share, one or more shares, and one or more directors. Among the particulars required under the Companies Act 2016, Section 14, subsection 3 provides that during incorporation you need to include a few things. First of all, the name of the proposed company, status, whether it's private or public, nature of business, proposed address, name, identification, nationality, ordinary place of business, ordinary place of residence, where any of these person is body corporate name, place of incorporation, registration number, and registration office of the body corporate. Other than that, there are a few other things as well that you need to consider. Other particulars which you also need to include is the name, identification, nationality, and principal place of residence for each director, secretary, and in the case of company limited by shares, the detail of class of shares such as ordinary shares, preference shares, and the number of shares to be taken by a member. Now, in the case of a company limited by guarantee, the amount up to which the member undertakes to contribute to the assets of the company in the event the company is being wound up, and it can also be any other information as the registrar may require. Now, when you reserve the name of the company, basically Section 26 subsection 1 provides that the name is available unless the company itself is undesirable or unacceptable. The name is identical to an existing company, corporation, or business, or the name is identical to a name that is being reserved under this act. So assuming another person has actually reserved that particular name and is similar to your name, it might not be available. Okay, or the name of a kind that the minister has directed not to accept for registration. So normally the minister has a list of the name, company's name, which you might not be able to actually use that particular name for your company. So basically the registrar normally shall confirm availability of the proposed name if he is satisfied that it does not actually contravene any of the provisions in Section 26 subsection 1. So any party who is aggrieved by that particular decision of the registrar shall can apply within 40 days of the decision, appeal to the minister, whose decision will be shall be final, to which you can no longer appeal. So in that event, just choose a name which does not actually contravene anything, and it is within the ambit of the Companies Act. Basically, once the registrar is satisfied and once you have made the payment of the prescribed fee, registrar will enter the particulars of your company in the register. Registration number will be assigned to the company, and the registrar will also issue a notice of registration. Okay, then comparatively, under the Companies Act 1965, certificate of incorporation is a conclusive evidence that the company has been incorporated. In fact, the certificate of incorporation is compulsory. However, Section 18 of the Companies Act 2016 provides that notice of registration that is issued under Section 15 is most important. Now, upon registration, Section 18 also provides for the effects to which, once registered, the company shall be a company in the name and registration number is stated in the register. So, the fact that it's registered, the notice of registration itself is a conclusive evidence that the company has been duly registered. Now, a registrar can refuse to register a company if you have not met the requirements under the Act, you have not complied with it, and if there are proof that the company is to be used for some unlawful purpose, and if the company purpose is actually prejudicial to the public order, morality, or security. So basically, pursuant to Section 16 of the Companies Act 2016, the registrar can refuse to register a company if all these requirements are not being complied. Now, perhaps we can look at this case. R.N. Registrar of Companies ex parte Mo, reported in 1931, Volume 2, King's Bench, at page 197. In this case, the promoters desired to set up a company to sell the lottery ticket in England, which at that particular time it was unlawful to sell lottery tickets, compared to the situation now in England is no longer unlawful. So at that particular time, the registrar refused to register the company. So what happened was the promoters took the matters to the court, and the court decided that the decisions by the registrar is correct. So the registrar can refuse the registration because the object of incorporating the company was unlawful. In fact, in the case of R and Registrar of Companies, ex parte AG, reported in 1991, in the Journal of the BCLC at page 476, the court held that where a certificate of incorporation has been issued, but later it appears that the object of the setting of the company was unlawful, the Attorney General can institute proceedings to cancel the registration. So even if you think that your registration of your unlawful company has been cleared, but if they found that it was everything all unlawful, the SSM can have the power to actually to cancel the registration. So basically, that's all about formation of companies. We have looked through incorporation of companies. We have looked through the effects of the companies, lifting of the corporate veil. We have also looked into the types of companies, and today we have looked into the formation of companies. I will not go into detail because you will go into details on each particular sections when you are doing your corporate secretarial practices. So what you need to know is on the procedures and the law relating to those refusal of incorporating a company. We will continue with the next chapter later.